chairs, Shailesh Saab, Naik Saab, Dr. Rasik Ravindra Saab, and delegates and students. I am neither a scientist nor a geopolitician, neither a diplomat. I am a lawyer who works in the Ministry of External Affairs, so you can understand my handicap. But I've been associated with the ATCMs earlier, and so I would largely be speaking on what this act is, or what are some of the principles of the act, and why is the act, necessary at this given point of time. And I've been involved with the Ministry of Earth Science, which was initially called the Department of Ocean Development, not only to have certain liability provisions in the act, but also, how the Professor Ravindra was there then, how this particular act should take shape. Why do we need an act? I think students of international law would know this. Not only does an act under the municipal system we have in India bring about legal certainty, but it also ensures that India has well-defined international obligations. And these obligations under the constitutional setup which we have in India, we call that as a theory of incorporation, where not only do we agree to whatever is there in the 5 treaties of the Antarctic Treaty System, but we also, make it a point to incorporate many of those obligations in our domestic act. So I think the first plus is that this act creates and provides legal certainty. Not only is it important for scientists, for policymakers, but also the general public at large to know that there is an Antarctic treaty which one can claim, which should have been, if you look at the jurisprudence of the Supreme Court and many decisions it has been given, areas which are fragile, areas which can cause transboundary harm, or areas which require common property externalities, they require some amount of clear, logical as well as written laws on the subject. So in that sense of the term, I think this act is important. It also, if you look at, I know sir, you've been associated with Space Act, space laws, and there has been a long-term desire to have a space legislation. I've also been a part of that committee that looks into this. So common property spaces, it's very important not only for reasons of ownership of what you do, but also for reasons if there is damage caused, then how this damage can be addressed and how issues can be settled. And Professor Patel is, Vimal Patel is there, whose product this particular act is, under whose leadership this has come about. I will just take a few minutes to tell you as to what are those important principles of international law in general and environmental law in particular, which this act reflects. I'm sure all the scientists know that it's not only is Antarctica supposed to be a zone of peace, it's also supposed to be an international protected area. Even though rights of sovereignty and of a large number of nearly 7 states have been frozen, and frozen doesn't mean that they cannot revive. They can always revive when the international community or an ATCM actually decides this. And this particular laboratory which we have, which Professor Chaturvedi so clearly brought about, not only is it a place where you have problems of climate change, but you also have problems of research actually being undertaken and the fruits of this benefit being known to all other countries around the world. Last week I was there in Bonn for this climate change COP, and I think one of the biggest arguments of most of these NGOs and the small island developing states was that the international community is not sufficiently sensitized to countries sinking, or as to why countries are suffering. The entire demand for this Warsaw International Mechanism for Loss and Damage. So a large number of effects of what happens in Antarctica, a whole ice shelf breaking into two. A year back we have seen the effects are not only felt in adjacent countries who have sovereign rights, but they are felt around the world. So I think it's not only the treaties you have, but the implementation of these treaties in good faith, which actually remains as a challenge. And I think it is to India's credit that many of these aspects have been reflected. Just to name a few, the definition of Antarctic environment, which to a large extent I believe has been borrowed from what the Brits have, it not only incorporates an ecosystemic approach, which we don't have in many other international treaties which India is a party to. It brings together a number of other issues which may not be of material value. You have issues such as intrinsic value to Antarctica. You also have, including its wilderness and its aesthetic values. You also look at research that is essential to the understanding of the global environment. These may be not of immediate concern to India. Yeah. So I think this is, if you tell a person, the greatest challenge to treaty law is that a person may not be affected by a penguin dying. It doesn't really affect you in the immediate vicinity. But a person would be really worried if a cross-boundary product is missing. So I think this definition gives you a larger understanding of how things need to be taken into consideration. It's not only material damage, but also larger damage. It also incorporates a polluter pays, a precautionary approach, not to wait for damage to actually happen, but to take a preventative approach to protection of the Antarctic environment. It also brings in, I'll just list this out, there are issues regarding nationality which have been borrowed from the Australian and as well as the Canadian practice. There are jurisdictional issues. There are issues of a permit system. A very well-defined permit system is given not only to an Indian, but also to a foreigner or a foreign registered ship that actually wants to undertake an activity from India or with an Indian national. You have issues regarding a complex and a well-defined system of environment impact assessment, management of waste. You have again a linkage between law of the sea as well as the Antarctic Treaty regime on prevention of marine pollution. Slightly dicey area, but I think it fits in well. And liability. I'll just take 1 minute more, sir. Liability is also, I think the threshold of liability is that of no fault. You don't need to require a standard of proof. It is more than what a due diligence test can mean of a rational, prudent man. It's much higher for a fragile environment like Antarctica. You also have, an obligation created to immediately to take a response measure, either by the operator or by another party. And if this has been done, the Act says that, the person who has actually done this, he is within his rights to demand, compensation for an equal amount for whatever he has done. Of course, there is no compensation, no punishment, no punitive sort of damages anywhere given in. Unlike, because there are no territorial claims, so you don't have any issue of punitive damages. So, the time being short, sir, I would sum up by saying that it's an act is only half the job done, drawing of an act. The real challenge is in implementing it, and the experience I'm sure which India has had with a large number of activities in ATCM, as well as the practice of other states would go a long way in not only forming up rules which are missing or regulations. Of course, the Antarctic authority has power to not only do inspections and look at liability, also to appoint and frame a large number of rules. This would be done in the coming days. I think I'll end here. Thank you so much.